a settlement order for civil case 165 UCV 0771, Walker County, Commodore for versus Stan Wright Lowe Jr. and Jill Marie Weiss, condemnee. Please see the attached exhibit E. I'll read one of these, and basically both the same. We've got two of them here tonight. And we'll talk about this a little bit. This is the above, this is Walker County, political subdivision of the state of Georgia, Condor versus 8.42 acres of land and 0.490 acres of land, Stan Wright Lowe Jr. and Jill Marie Weiss. It says the order the above and foregoing matter coming before the court upon the petition to set aside a declaration of taking filed in the above styled action by Walker County, Georgia, pursuant to the OGCA 32-3-11 and based upon the agreement of the parties as evidenced by their signatures to this order. This court's entered an order on November 17, 2016, granting the taking of certain property of the condemnee. The condemnees have filed a petition to set aside the declaration of taking and has filed an appeal of the previous order. This court finds that there has been a change in administration since the filing of the petition in this case, and the new sole commissioner has been elected as the governing body of Walker County, Georgia. The commissioner does not wish to proceed further with this action. The parties agree that the previous order of this court dated November 17, 2016 should be set aside, vacated, and annulled, and this court concludes that pursuant to OCGA 32-3-11, said order should be vacated. The parties further agree that all appeals, motions, and other matters relating to the arising of this dispute should be dismissed. It is hereby ordered that the order of the court dated November 17, 2016 and the above entitled action is set aside, vacated, and annulled in accordance with OCG 32-3-11, and all the provisions of said order shall hereby declare null and void, and all appeals, claims, and pending motions and parties relating to or arising out of litigations hereby dismissed. It is further ordered that the title of the subject property shall revert to the condemnees. It is further ordered that the clerk of the Superior Court is directed to pay all funds deposited with him as part of this action to Walker County, Georgia, and it is marked that this action dismissed and terminated pursuant to this order, so ordered, and has a place for the date for the judge to sign. Arch Ferris, the attorney in Somerville that represents the other party, has a place for me to sign as commissioner, and also Robert Smiley was the attorney that had been hired by Walker County that started into this original condemnation. In summary, what this was a road up on Lookout Mountain. It was Vulcan Drive was the private road name of that road that was owned by Stan and Jill. And back on November the 17th, B.B. Haskell entered into an order to take that road. So since that was an actual road, the way the state law is set up is the local government has the ability to take that road without notice. They can take it immediately of the judge signing that order. No questions asked, they can just take it. And so they did a condemnation or an immediate take of this road to try to pull a situation where they could go in there immediately and start grading and start trying to make an additional trail. For 5 years, or maybe longer than 5 years.
8 years.
8 years, Walker County was trying to take the position that Walker County had a quitclaim deed on this property. There's a lot of history that Jill Weiss could share with you about the ups and downs of that, but it was very interesting on the court hearing on November the 17th that the attorney representing Walker County, which was Robert Smalley, in his opening statements admitted that Walker County had come to the conclusion through further investigation and title search that Walker County did not have a quitclaim of this property, And therefore, they were having to do this immediate take and do this condemnation because Walker County didn't own it after all. The only reason that I was there at that hearing is I had got wind that this was going and taking place. So I had to hire an attorney to represent me as the incoming commissioner. I notified Jill and Stan they had to reactivate their attorney, and we were all there waiting for the order to be delivered to the judge. They didn't know we were going to be there. Because again, they can do an immediate take. They can just take this with getting a judge's signature. So they thought they were going to be able to go in the judge's chamber, get the judge to sign the order, and the next day they were going to start knocking trees down. So by state law, the judge was bound by that order to sign that order. And my attorney agreed with him. He had to sign that order. But what he did have the ability to do was to put a 60-day stay on that order to keep anyone from disturbing that land, knocking down these trees, tearing up the mountain for a trail. And so the judge did enter into an order for a 60-day stay. It has been extended a couple of times because, as I told Stan and Jill and the other parties, I wanted to make sure that I was making an informed decision and that it was, if it was or was not in the best interest of Walker County to continue to maintain that land. Because it was, the way I looked at it, it was taken away from private owners that was trying to mind their own business for the greater public use of Walker County. And after doing some research through the different organizations that do trails and looking at the regional commission and studying and reading different documents and trying to get myself up to speed on this, I didn't see that there was any benefit for Walker County to own this property. And so we have gone back and forth with the language and documentation and trying to get this where we kind of cross all the T's and dot all the I's, so to speak. Jill and Stan have been very professional and very good to work with. And I don't see that it's in good order for Walker County to continue to spend thousands of dollars to try to develop trails when we're broke. So we wanted to settle one of our lawsuits and get this behind us, and we've come to a mutual agreement and understanding, and so the courts will be paying back the money out of escrow back to Walker County for where the previous administration actually took this property from private citizens for development of a trail. Anybody have any questions or comments?
I'm gonna make this easy, mine yes or no, because it really doesn't pertain to, the property, so to speak. Are we, and I'll read it verbatim, is Walker County abandoning the Durham Trail completely?
The Durham Trail, it says, is Walker County abandoning the Durham Trail project completely. The situation that we're in is we don't have the money to continue to do any work as far as trying to build trails anywhere in the county, and we sure don't want to do it by condemning people's personal property.
Absolutely,
So there's a lot of existing trails up there. Many of those are in conservation easements. Some of them are owned by different landholding organizations to preserve those. And some of
I'm
them.
only talking about the Durham, just the Durham Trail that goes through 4 or 5 pieces of property, which
The
the
problem.
only piece that wasn't completed was the one that our last administration was trying to.
Well, what has been determined, and the previous administration finally come full circle and admitted, is Walker County does not own the rights to the old Durham line.
Okay.
Those have reverted back to the property owners, and so.
Okay, that was one of my other questions. So the property that the trail, let's see, like I said, we need to read it verbatim. Since you're returning Mrs. Weiss, Mr. Lowe's property, will the other property that was included or that was part of the Durham Trail, is Walker County going to be deeding that back to the original owners then?
Which property are you speaking of?
Well, I think it's 4 or 5. If you look at the map of the trail, the way it runs through 4 or 5 other people's property.
Yeah, we'll just have to look and see what other ownership's been done, or if that was sold, or if it was donated. I mean, I don't know all the circumstances of all those,
We do know. We can tell you
but I
right
don't
now.
think they were done by condemnation, were they?
No, they most certainly were not. And when you talk 4 or 5 pieces of property, the initial section of the Durham Trail that comes off of Durham Road actually crosses Little Lake Land Trust property.
Right.
The
that was
Gaskin
like years
Malloy
ago.
property, the Gaskin Malloy actually granted that easement to Little Lake, not to Walker County.
Mhm.
And then the second part was taken by Don Oliver intimidating and browbeating Jackson Wingfield to give his property up, which he traded because Don's threatened and said, if you don't give me that property, that I'm gonna take this trail right down through the middle of your property, right by your creek.
Right.
So that is a section that Walker County has, which I hope they do give that back
Right,
to
and
Jackson.
that's
It's
my
only
question.
fair.
Are we- if
The
we
third
give it
piece
back,
of
we
it,
give it back.
and that, might I add, is the only part that's on the railroad bed. The rest of the railroad bed had been caved in. The third section is a Warren, Mr. Warren had given permission for the people to go up on a road that goes over the railroad bed. Now, we've never been able to see a deed. We'd asked for one, never furnished one, so we don't know what kind of agreement that Mr. Warren has, and if there is even an agreement.
Right.
And then it goes across to land that was given, not donated, but given in consideration for money from the Gaston Rowell estate. Now, Gaston's been dead. I knew Gaston. Gaston would pitch a fit over that going to a trail because he really treasured his property. But where it goes across trestle number 14, if you go and look, and I actually brought my computer with pictures, it comes across the trestle. The trestle, for years, people dumped there. We don't know how they got in, but if you look off the side, there's 70 tires that we counted the other day that are visible. Car chassis, truck chassis, and that's the park that Don Oliver had claimed that we had been blocking, which is ridiculous.
Yeah, I walked
So-
the trail that time when I called you. I walked
Yeah,
the whole trail.
well then, did you
Yeah.
saw the
Yeah,
dump?
yeah,
You saw,
yeah.
and it's not even a trail. It's very, I mean,
Well, that's my.
It's
okay,
ridiculous.
So back to my original question, Ms. Whitfield, is, I understand we're giving Mr. License for the property back. I don't have a problem with that. On the survey map, the Walker County map of property, it shows that trail running dissecting other people's property. It is deeded by the county records to Walker County.
I'm sorry, I've got to interrupt once again, please.
Okay, go ahead.
Just on the Walker County GIS, and this is something that we had spoken to the prior administration. If you look where it's listed, it shows that Walker County got 17.42 acres of that trail from Jackson Wingfield, and it cites a deed number. You get that deed, and you get that deed number and look at it, and the actual deed is for 1.42 acres of Jackson's property. Somehow it got extended falsely to run all the way down as though that property was given to the county from Jackson, and Jackson never had ownership.
So is
It
that-
was
so
a
is
Don
that something-
Oliverism.
So is that something
Don
that needs to be
Oliverism.
changed on the, I mean?
It
that-
hasn't yet, but we hope
inaccurate?
it will be changed,
Well, I mean,
but, well, I haven't even brought that up to Mr. Whitfield
We're doing
yet.
this in steps because this was a pending issue that the courts either wanted to hear the appeal, or hear the case, or get it settled. So we were able to come to agreement on this, and it did not make sense for the county to continue on this. Your next question is there anything in writing stating that the grant money received from state agencies or any other entities will or will not have to be paid back on the project if not completed? One thing that I did learn in my research is that if you have condemnation of property, you cannot use grant money, federal or state, on condemnation property for trails. And so the grant monies that have been done on any trail development does not affect this, nor has any grant money been applied for since I've taken office for this. So I don't think that's going to be an issue. Has anyone attempted to find a way to continue the project by bypassing Ms. Weiss or Mr. Lowe's property? I have no intentions of doing any trails anywhere in Walker County because we don't have the money to do it. And even if we got grants, they want matching money. We don't have the matching money for the grants. Has the EPA fines that were incurred by the previous administration been paid? If not, do you intend to pay them and when? I haven't yet found any documentation of this yet. I know it was talked a lot about during the campaign. I have not heard from them, seen them, or have received anything, any correspondences from them. So that is, at this time, an unsettled issue at this point.
It's sleeping dogs.
Are we gonna pursue it or just kind of?
We're gonna get it handled and settled, and we'll just have to enter into the conversation with the EPD to see what we gotta do to bring resolution to it as well, and get that behind us. It may or may not include, money, I don't know yet, so we haven't had that conversation. And then we'll get to your other questions on the other items.
Can I say one more thing,
Yes.
please? I just want to clarify, Don Oliver had put out so much false information about this that he called and says that where that goes through our property was Vulcan Drive, but actually by the county road records, Vulcan Drive stopped at the gate, and that was our driveway that he was calling a road, which it had never been. So, anyway, thank you.
Yeah, it's,
No, it's definitely gone on way too long. It needs to be settled. I mean, it's been.
Thank you, it
ridiculous
has.
fight.
And we've spent a lot of money on that too, that we should never have
Yeah, I
had
mean, we spent
spent.
what, $350,000 pretty much on building, I guess.
Actually,
nothing down.
not 350, but it was a lot, but it wasn't 350. I've got all that documentation. I'll share it with you sometime.
Stan, did you have something to add?
I was just gonna comment, as far as the road, I mean, it's our driveway, no one should infer that it's a public, that it was ever a
Right.
public road.
It was a private drive that had a road marker probably for 911 identification or emergencies or things of that nature.
That was it, to get down to the cabin, but the gate had been there, and it had been there since the 80s, and we even, the road documentation and everything stops it at the gate. Don just tried to call it whatever he could to get what he wanted. So,
Ma'am, do you need somebody to come up there and pick up those tires and haul them landfill?
if you saw where it was,
I need your help.
let me tell you, I'll get your number. Although it's on county property.
I'll do a better deal with you.
All right, we'll go ahead and sign this one. And then I won't bore y'all with all of the reading of the next one. It basically is stating the same thing, it's just, it's a different civil action. It's got some additional parties, listed that, are all family members of another parcel that they all own together. So it's basically the same documentation. And we'll be forwarding this to, the attorneys and to the Superior Court judge for signature, and everybody's on the same page of getting that settled. It was listed in those documents there. Okay, we have a resolution for a moratorium to acceptance of permitting and the related activities of hydraulic fracturing